Hi, my name is Amanda Rocha. I'm an estate planning and probate attorney in California, and today we are going to talk about the privacy of your estate plan. Before I get into that, I want to give you my contact information. You can find me on my website, www.amandarocalaw.com. You can comment down below if this platform allows you to do that, or if you follow me on social media, you can send me a direct message at Amanda Rocha Law. Now, why are we talking about privacy here? Many people are concerned with whether or not their property and private information remains private after they've passed away. And in some instances it does, and in other instances it's public information. So let's just dive right into what happens. If you pass away without any kind of an estate plan at all, which is known as passing away intestate, then your estate will most likely have to go through probate if you own more than $166,250 worth of assets in California in 2021. That number is subject to change. Anything that goes through probate is public information unless a court were to seal it for some reason, and that generally doesn't happen. By public, I don't mean free, but if you're willing to pay a couple of cents a page to make copies, or if you want to go sit in the courtroom while probate proceedings happen, it's all public. And anybody can collect that information, including your creditors or potential creditors, neighbors, family members that may have an interest in what you have. All of that is public. Now, if you pass away with a will-based plan in California, your will still has to go through probate if that is how you've based your estate plan. Anything that goes through probate, again, is public information, and anybody can get that. So your will has to be submitted to the court. Your will can then be taken, people can take copies of it and look at it and review it, and it's all public. They know what you own, they know what it's worth, they know what's going to happen with it, and if they have any claim to it at all, then they can enter that claim in the probate court. A trust, on the other hand, is a private document that is an agreement made between the person who creates it, the grantor, and the trustee. That is all. The attorney who creates it for you, the trustee, and the grantors are the only people who need to see your trust. If you have property held in trust, so let's say your trust owns your home or some bank accounts or other accounts, the people who actually have to change ownership, so the recorder, county recorder, or if you're talking about a bank, they don't get a copy of your trust. They only need to see a certification of your trust. So your trust is a private document. It doesn't get submitted to a court unless it's submitted as evidence for a will because the trust wasn't funded correctly or it failed for some other reason. So the most private way you can do this is have a trust-based plan and make sure that anything that you own after your trust is created is either entered into the trust, or you are working closely with your estate planning attorney throughout your lifetime, every year, 2 or 3, depending on how often you purchase items or sell items. You update your estate plan so that if something were to happen to you, and when something does happen to you, it isn't for the entire world to see. If you have any questions about whether or not something is private, let me know. We can talk about joint ownership as well and whether there's a privacy issue there. If you want me to create a separate video, make a comment down below, send me a message, shoot me an email, give me a call. You can find me on my website, www.amandarocalaw.com, or on social media at Amanda Rocha Law. Thank you.